will come in. I'm just...
Council, try and keep it short.
We will try and be very short. One of the things is, when does the period of remand count? And I'll start by giving the court an authority, which was determined in April this year by Justice Isaac Wanta. This is application number 133 of 2025, arising from criminal number UPDF GCM 022 of 2020. Besigye applicant versus Uganda. And in this case, I will not go to the details, but I'll come to the end of it, where the court says, I find that the applicant has satisfied the requirements for mandatory bail and Article 23(6)(c) of the Constitution, Section 15(2) of the Trial on Indictments, case detention of over 1,500 days without trial, and committal qualifies him to be released on mandatory bail. This person, the 1,500 days being referred to, is the remand in the general court martial, in the court martial. So this authority sorts out the matter of whether the period of remand in the court martial counts. Number two, it would be absurd to construe the period of remand as 3 months. And I'm urging this court to take judicial notice, because these matters have been very public. Since the judgment of the Supreme Court on the 31st of January this year, the A1, A2 have been in court applying for bail, and the prosecution has refused to concede to bail. They were not released by the authorities even after the judgment. How then can the court take the period of remand under the general court martial in asylum? Before we came before this court, under what warrants were they being held? Was it to the order of the state, which continued to oppose bail application? My friend cannot approbate and reprobate. He must decide what his submissions are, but not one time to oppose bail and say they are lawfully held, and then to come and disown the period for which they were detained as an extension of the proceedings in the general court martial. In fact, doing so is admitting malice, because if there was no connection, then the Attorney General would have been the first to say, release them, we are now doing new investigations. The Attorney General did not do that. So the submissions of my learned colleague, the prosecutor, is actually orders on admitting malice on part of the Attorney General. The court should not be caught in this conspiracy to deny the accused persons their liberty. I don't want to go back to Article 23 because it's very clear. It doesn't say the High Court only. It says, C, B says, in the case of an offense which is triable by the High Court as well as by the subordinate court. These committal proceedings are part of the trial. So the subordinate court initiates, and the High Court continues with the trial after committal. If that person has been remanded in custody for a period of 60 days, so if it was this court, we would have come for bail earlier. But because it's both, if you look at C, it's both the subordinate court and the High Court, they've been in custody for over 180 days. And it's very clear that if before the case is committed, and exactly that is where we are. We are applying for bail before this case is committed. Are we entitled to do that? Yes. And that's where we refer you to the Magistrate Court Act, Section 76. We are not doing it just because we dreamt of it. It's the law, it's written in black and white. That in respect, this is 76B. 76B. A. In respect of any offense punishable by death, if for a continuous period exceeding 180 days, which is where we are. If you allow me not to read B, to go straight, the magistrate before whom the accused person first appears after the expiration of the relevant period shall release him or her on bail, shall, on their own cognizance, notwithstanding that he or she is accused of the offense. So before any other act, before any other application, including the committal, and we were not aware of the committal, we came for our bail application. It's today that we are becoming aware. So if the court were to look at who has been delayed, we were at the court martial for several months. They never commenced the trial. We've been before the civil courts for the whole of February, March, the whole of April, and this is the end of May, 4 months. Who has held the prosecution from concluding? He cannot come and infer improper motive on us. Your Honor, there is very little room left for you. There is no discretion in this matter. You must admit them to bail. But you have discretion as to the terms. Let my colleagues finalize. I am aware that the court has requested we finish the trial to be
committed to the High Court for trial prior to the committal. So there has not been any committal before the expiration of 180 days. Even if there is any committal proceedings to be taken in the future, it doesn't constitute the jurisdiction of this honorable court from going ahead with the mandatory thing. Second, the proceedings that may be considered later would not operate as a bar for court to proceed with this command of the law. We would like to ask this honorable court, Your Worship, to look at the spirit of this particular provision, why it was enshrined in this, why it was put into the Constitution, and it was couched this way in Section 76. Why this particular provision was couched? To stamp out persecution, impunity. It was intended to stamp out impunity and persecution. When you look at the provisions of Article 43, the framers of the Constitution were arrived to that fact that the state may exceed what is actually within the limit of what they have powers to deal with, and descend into the realm of persecution. And that's where we are now. That's the limit. The reason there was that limit of 180 days, and the court was given those powers that these, once the state has failed to take steps to commit the accused persons within 180 days, first appearance before you as a magistrate. Don't do any other thing. Please just consider releasing the accused persons. And that's what we are asking for Your Worship. This honorable court should acquiesce of the unaccomplices in the persecution of the accused person by the state. So the only thing that should be done at this stage is to release the accused persons. So in such conditions, you will be moved forward. We do so, Your Worship.
I just want a clarification. Does it mean that the pre-trial handling of this case in this court continues after the commitment that you have just made.
That application has been given a date. The lawyers can follow up on that date. For now, it's been committed to High Court.
Before you check this, we need people to record for having supplied the test to the court of the indictment.
Ngozi ngomuna muzimba mukwala yachigaragara mukwala kuba kama mbira bakwala ngulabi nalo kagamba kwete mukwala public servant agara mukwala we have given you a copy of the it was on record kopi bainasiwa wakati wasome section ngabainasiwa accused. You are given the defense lawyer not when I'm going to let me produce the copies. I'm not going to go to the yellow. Yes,